in the way back, probably just shows how old I am, which is old. In the 1980s, there was a movie called Scarface, and the guy was like a Cuban guy who had become a drug lord in Miami or whatever in the 1980s, and there's a scene in there where he gets caught, not for pushing drugs, but he gets caught for laundering money, like trading money for, swapping it out with somebody else for, percentage of the profit in order to account for all the millions and millions of dollars in cash that are coming in. And so he gets caught, his own video and all this, So he hires a lawyer, and the lawyer comes in and looks at him, and the guy says, I want my rights. I'm presumed innocent. I'm not an idiot. And the lawyer looks at him, and he says, under the law, he says, to be convicted, he says, the government has to prove that case beyond a reasonable doubt. And he says, and Tony, honey, baby, he says, I am an expert at creating that doubt. And he says, but it's awful hard to do when you're sitting there and there's no other explanation for you having $2 million in 20s rolled up in duffel bags. And that's sort of the situation that we're in here. I understand Mr. Gamble's a great lawyer. I mean, he is. He's an excellent lawyer, and he can find these things and create it. And that's why, literally why, I ask you, so when you listen to this, nitpick, wait for an answer to this question. What do these things really have to do with the death of this child? And we're going to talk about it. We're going to talk about the poor parenting and the dirty diaper and the vomit on the jacket and all of that as we get further in. But first, ladies and gentlemen, what I want to do is I want to talk to you about what the charges are and what I have to prove. Okay, these are the charges that are in the indictment. Okay, and I'm sort of starting actually. I think I'm starting kind of in reverse. I should have gone back and put them in the order of the indictment. But there's a reason that I wanted to do them this way. And that is that I wanted to start with what's kind of the underlying felony charges, which then, go up the scale as you add other things. So aggravated battery, the state has to prove the defendant maliciously harmed the person by rendering a part of his body useless or seriously disfiguring a part of his body, which the evidence in this case establishes that J.D. Angeli's brain was essentially rendered useless, that his liver was rendered useless, his liver was disfigured due to massive lacerations, and so forth. For first-degree child cruelty, the state has to show that the defendant maliciously caused cruel or excessive physical or mental pain to a child. Now, both of these charges include the phrase malice, or the word maliciously. And the law, and this is what I think Judge Southman was going to charge you to all of these things. That's the reason I'm putting them up now. And I think you may actually get a copy of the charge with you. And if you don't, if there becomes a question and you think, we need to be clear on this point of law, all you got to do is say, hey, Judge, can we get a recharge on this or that? And they'll come back and tell you this again. But malice is not necessarily ill will or hatred. It simply means an intent to cause pain without justification or excuse. Malice also means willfully, intentionally doing an act while aware of a strong possibility or strong likelihood that pain may result. If you pick up an 18-month-old baby and you slam him down on a piece of furniture or on the floor or against the wall, whatever, with the degree of force that's necessary to fracture this bone, with the degree of force, in a separate blow, with a degree of force that is sufficient to tear his liver practically in half, okay, then folks, that's malice. Because you can't do those things to anyone, particularly not to anyone, a child or anyone, without knowing that it is a strong likelihood that pain is going to result. So if you find Trinity Poague guilty of aggravated battery or cruelty to child in the first degree, and I submit to you that you should find her guilty of both of those charges. If you do, then that brings you to felony murder. And what felony murder is a person commits the crime of murder when in the commission of a felony he causes the death of another human being with or without malice. Okay? So in other words, it's not a matter of did somebody intend to kill him? Was somebody aiming to kill him? Was it a specific, I'm going to, I've got an hour, I've got 30 minutes, I'm going to kill this baby right this minute. Kind of thing. Don't have to prove that, okay? Don't have to prove a specific intention or intent or desire to kill. All you have to prove is that the felony, the underlying felony, was intentionally committed with the person knowing that it was likely to cause pain. And if you do, then that leads to the finding, I think, almost necessarily, I say I think, and not I think, but I don't, when you look at it, how do you analyze this? Do you find the felony, and then you look at this charge, which says that if a person dies in the commission of the felony, then that's murder. Well, that's exactly what happened here. And that circles back to where we were at the beginning of my first part, which is that the question is who caused the trauma that killed the baby within that time frame? I mean, that ultimately will answer those other questions, okay? Because if you know the answer to this question, then you know the answer to to whether the defendant is guilty or not guilty of those other charges that have been brought. I fully understand, I respect, and I honor the burden that I come in here with, and the judge is going to charge you, and there's no question about it. Mr. Gamble argued it, and he's absolutely right. The defendant is presumed innocent, and that presumption carries with her throughout this whole trial. She had it when she came in this courtroom, okay? She has it when you go to the jury room, okay? But when you look at the evidence, and you find that the evidence is sufficient to overcome that presumption, when you find that the evidence is sufficient to show you beyond a reasonable doubt that she's guilty, then the presumption goes away. Until then, she certainly has the benefit of it. The law says that nobody can be convicted of a crime unless the case is proven against them beyond a reasonable doubt. We have to prove all the elements of the indictment in order to do that. The evidence in this case is not it's not as complicated as Mr. Gamble wants you to think it is. It's actually fairly simple at this point. And that is, okay, we start on Saturday, January 13th. Jay Williams was in Colquitt. JD was with him. He had been up here. He'd been up here earlier in the week. He'd stayed here like Thursday night, Friday night. Okay, he had stayed at her dorm, or in a motel, whatever, at Hampton Inn Thursday night. This is his testimony. He'd stayed in a hotel there. She'd come over, and then Friday he was going to stay in the hotel again. And she came over, and when she came over that time, and she didn't want to stay, she said, because they're breaking up, she's breaking up, right? So she wants to leave, she wants to go. She goes back to the campus, and when he doesn't come with her to the campus, she calls him or texts him and lies to him about having been in a car wreck. She lies and says, I was in a wreck. And he told you that, of course, his reaction to that is he took off to the campus, to check on her, and she was in a wreck. She wanted to talk to him. And so it was sort of reverse stalking. Like, I'm not, instead of following somebody, you say, here, come here and follow me. And that's exactly what she did. So on this day, the next day, January 13th, she's in Americus, he's in Colquitt. She wants to go to Chipotle in Albany. Okay, so she asks him to meet her there. He doesn't call and ask her out on a date. He's not planning on going anywhere, and that's what his testimony shows. The reason that he wasn't planning on going anywhere is because he was going to be home with his son, with JD, and nobody else was there. His sister wasn't there. Didn't have anybody else to keep. Didn't trust anybody else to keep JD. And so he tells her, he says, you know, I'll come, but I've got JD with me. And she says, well, come anyway. Just bring him with you. They get there, they eat dinner, they go to Sephora. You know, she swaps the car seat from his car to her car because it says that according to his testimony, she says that it would maybe give her a little time to spend some time with JD, you know, while she's driving and you know, work on building some kind of bridge or relationship with him, etc. So then she says she wants him to come back to Americas with her. And the car seat's in her car already, and he says, yeah, okay, I'll come back to Americas with you. Okay, so at this time, when they're in Albany, okay, this video is from, it's one of the videos that was played. I mean, it's not a video, it's a screenshot of the video, okay? But this shows the child in the car. Okay, this is when Jay Williams has left Colquitt and is coming to Albany that this video is taken, okay? And he's wearing his little blackie Nike, his black Nike is what I'm trying to say, his black Nike hoodie and not hoodie, jacket and pants, his suit, tracksuit or whatever, which is the same thing that Jay Williams was wearing himself. He made reference to it that was they had matching outfits. Okay, this is what this child looked like. Okay, there's no bruise on this side of his face. There's no marks on this side of his face. His face isn't swollen or anything else. That's what he looked like when he's in Albany. Okay, now there are these claims that were made in opening statement. Okay, that have turned out to just simply not be true. Okay. In opening statement, the defense says that Jay was drinking when he met her in Albany, and she just couldn't send JD back to Colquitt with him, so that's why she took the child, and then she let them come to Americas with her because they wanted, they wanted to go to Americas, or Jay did. That's what you were told you would hear. There's no evidence that says that. There's no witness who testifies to those things that you were told you would hear. In fact, what happens is on January 13th, if you look, after she has asked him to drive from Colquitt, from Albany to Americas, okay, before she's even back at the dorm, she texted Paris, and she says, "Are you coming back? I got stuck with JD." Paris says, "Yeah, I'm coming back." And she says, he made me feel so bad because it's already late and JD is being so fussy. So he asked if they could stay. And ladies and gentlemen, there's just no actual evidence that is what happened. And in fact, it doesn't make any sense at all that he would have done that, because if he's in Albany, he'd be closer to home than he would be to here. So on on Saturday, then what happens is this. They get to the dorm, they go through the doors, and you saw the video from Georgia Southwestern. They go through the doors at 10:06. He testifies that he blows up the air mattress for Poague and JD to sleep on. Trinity Poague and the baby are going to sleep on the air mattress. And there's not a lot of explanation for why that is, but the context of some of the other messages that we'll get to later, and I think the testimony of Paris in this trial suggested that typically when JD was here that he would sleep on the air mattress with Miss Poague. That night, Paris came to visit them. Okay? She wanted to see the baby. She left work on her lunch break. She came to see the baby. She says that when she saw him, he was perfectly okay. He didn't have any bruises. He didn't have any marks. He didn't have any tenderness or soreness. She picked him up. She hugged him. You know, they kind of played around, and he wasn't tender. He wasn't shy. Wasn't any of those things, okay, because he hadn't been harmed at this point. He doesn't have any bruises. He doesn't have any injuries. Jay Williams fell asleep on the bed watching TV. So let's take a pause here and figure at what's the baby's physical condition at this time, okay, which is 10:30, 11 o'clock on Saturday night. There's no evidence of bruising, pain, soreness, or any injury. The only thing that was said was he might not have been hungry. There was some allegation that he didn't eat much. Of course, Mr. Williams said the reason he didn't eat much at Albany or wherever was because he had eaten in Colquitt before he came up here. Then that night at 11:46, Ms. Poague texted Paris and says, "Is it okay if I watch TV in your room?" She says, "Yeah." "Why, are you all right?" She says, "Yeah, I need a break, a mental break. JD isn't asleep, and Jay is knocked out all over the bed, and I didn't want to play the TV." Is what she says there. So 11:46, she's asking Paris if she can go to the other room with JD. So it goes Sunday morning. This is Jay Williams' testimony. He woke up. They woke up. She had gotten into bed with him off of the air mattress. They woke up. He said he woke up somewhere around 9, maybe something. Said she woke up like between 9 and 10, I think. Says that he picked up JD and he put him on the bed with them and he laid him on his chest for a little while and whatever. And then they got up to take a shower. Now, the allegation is that the statement from Mr. Gamble is that he says that they ordered the pizza before they got in the shower. Well, the testimony, and you will recall it, of course, was that they had talked about ordering pizza at like 10 or 10:30, but hadn't done so. And then they ended up actually ordering pizza, a little while later, and whether it was before or after they got in the shower that they ordered the pizza, don't know, but it doesn't matter. Okay, he gets out of the shower, he gets dressed, he says goodbye to JD, he leaves to go to Walmart and Pizza Hut, and at the time he left, and at the time Trinity Poague got out of the shower and went back in the room, JD was in that pink chair watching Katuri, a kids show on TV, and had a Mountain Dew and some Fritos Twister chips. Okay? So when Jay Williams leaves at 11:55, what's the child's physical condition? Again, no evidence of bruising, pain, soreness, or any symptom of injury. He might not have been hungry. That didn't come out very clearly, but that's at his worst condition if you hear the evidence. Okay, he's gone from 11:55 to 12:30. When he's turning back into the parking lot, he got back-to-back calls from Poague. She didn't tell him that anything was wrong with the child. What she did was she called and hung up, and then he said as he was parking and was about to get out of the car, she calls back, and she's not talking to him. She hears him saying, JD, JD, JD. So he gets the pizza in the Walmart bags, and he goes into the college, into the dorm. You saw that on video as well. And if there's any portion of those that we can't send videos to the jury room because there's no way to play them back there. But if you should decide that you need to see them again, all you have to do is ask, and we certainly, the court will make arrangements for that. So he goes in the room, she's holding the baby. He realizes that there's something wrong with the baby, and he did. He testified that he asked, what's wrong, and frankly didn't testify real clearly as to what she said in response to that. When he said what's wrong, but he wasn't waiting around to find out. He put the pizza in the bags down, put the pizza down, dropped the bags on the floor where they were, picked up the baby, and took off for his car, and he drove to Phoebe Sumter. At Phoebe Sumter, he went in with JD. The nurse met him and put JD on a gurney, and then he followed them to a treatment room. Now, Alan testified. So there's this thing that Mr. Gamble keeps making a big deal out of. It says that this note in the nurse's record. He says this note says that the child is limp and pale, that father present at bedside states child fell around 5 minutes prior to arrival. Okay? And that note has a time, an event time of 12:36. Okay? So Mr. Gamble wants you to interpret that as meaning that is what he told her at that moment when he went in, that he was standing at the child's bed when he told them that. And folks, there's other things in this note that we know it's not exactly accurate. It's close, but it's not exactly accurate. Okay? The note says that the child is in ER, and the front is taken to ER 16. From the front entrance of the ER, he is carried by his father, who is unresponsive. The father wasn't carrying the child anymore. He got met by a nurse after when he came in the door, went to the front desk or whatever, past the front desk, got met by a nurse and put him on a gurney, and that's what the other evidence was that you've heard. He followed them to the treatment room, but Allen says that he didn't go in the treatment room. He wasn't bedside. He can't go in there when they're doing CPR and they're intubating the child and doing all of those things. He remains outside the room, just outside the hall, in the hallway, and he does that. He does that because that's the only place that they'll let him go. So he's not bedside. Now, okay, by the time this note was written, he had been bedside. Okay? By the time this note is written, which wasn't actually entered until 8:04 p.m. By the time the note is written, he has been bedside. He was bedside when the child died. Dr. Bussman told you that. But he wasn't bedside when they were administering treatment, and he wasn't bedside giving a history. Okay? The note's written 8 hours later, and despite everyone's best efforts, okay, it's very hard to separate all of the scurry of events that happened over the course of, just a little bit of time with regard to the treatment of this child. Also, okay, Mr. Gamble says he told them that 3 times. That note is in there 3 times that he said that. He didn't tell anybody anything 3 times. Okay? The note is a nursing note on page 21 of 28 of the second batch of numbered pages. It's a nursing note. Okay? It's simply copied into the record because there's the nursing notes, there's a code blue report, there's physician notes, there's other reports, and they get cross-copied and copied on top of each other, which is why when you ask for your own medical record somewhere, you get 200 or 300 pages, that they want to charge you for, and you realize ultimately there's only 20 pages of it that really matter. Okay? And that's sort of the same thing here. The same records are copied over and over again because different people in different roles have to keep them. And then when we ask for all the records, we get them all packaged together. He didn't tell anybody anything 3 times at the hospital. And the hospital didn't write it down 3 times. It's one note that was written at 8 o'clock that night. Allen wants to talk to him. Allen said he was emotional, that he didn't want to talk to him there, and he didn't want him to keep standing there because he was upset. So Allen asked him to go out and walked outside with him. And Allen asked him to go outside, and he does. He told Allen, according to Allen, he told Allen that Poague had told him that J.D. had fallen out of a chair. Poague got there, and she told Allen that J.D. had fallen out of the chair. She specified it was one of those round beanbag, or at least he interpreted it as a round beanbag style chair. And she says he was eating chips and drinking juice, and she heard him fall over out of the chair. Not that he just simply slumped down, but she heard him fall over and hit the floor. Okay? That's what she tells Alan, not what Williams tells Alan. I mean, it's the same thing Williams told him, but it's not. But it's not his words; it's her words. Okay. You know, there is a reality to what we do that when people go back and you look at records and you look at notes and you look at reports, okay, from 2 years ago, and you ask people, you say, okay, I need you to remember line by line and word by word, second by second, minute by minute. Okay, I need you to tell me what did you say and what did they say next. You know, and then we come into court and we have these, you know, these prior statements, and you know, we've got reams of interviews and records from hospitals and doctors and phones and everything else, and we say, you know, did you say that? Yeah, I said that. You know, I mean, and they know somebody knows they said it. They know they said it at some point back there. You know, if you ask me, you know, if I said it to this person, and then you ask me, did you say it to that person? Well, 2 years later, it might be really easy to say, yeah, that's what I told him too. You know, because it's kind of hard to delineate those things, and that's just the reality of the memory. Okay, that's the reality of the memory, whether you're in a courtroom or, you know, you're sitting around, you know, on Christmas Eve with your family, and you start talking about something and say, you know, remember when so-and-so, and you realize that nobody there remembers it the same way you do. Okay? And you end up, you know, like you have, you know, people just like, no, it wasn't. That wasn't on Christmas. That was on Thanksgiving. And it wasn't that year. It was the year before. And so, I mean, the reality is that the only person who had information about what happened to this child was Trinity Poague. And she's the one who told Alan what Jay Williams testified to. Okay? What Jay Williams testified to, which is different than what Alan testified to, no doubt. Okay? What he says is that she was there and she told Alan in his presence, and that's where he heard the chair story from. In any event, ladies and gentlemen, the evidence as a whole shows you that it's Poague who is promoting that story, not Alan. I'm sorry, not Jay Williams. I'll go ahead and address it now. I'll skip it later. He says, you know, but ask him, did you tell Samantha Ford that you knew, you know, did you tell her what happened? And he says, yeah, I told her. I told her what happened. I'm sure I told her what happened. And it's like, okay, well, what you know, what'd you tell? You know, did you tell her he fell out of the chair? Yeah, I told him he fell out of the chair. Because that's what he told other people once he had heard it from her. But then he instead of getting the statement, the interview that that Ford had done with Jay Williams, okay, what Mr. Gamble does is instead of showing the interview and saying, look, you know, do you want to refresh your memory about this? Be sure that you know what you said. He doesn't do that. He's charging him with being able to have in his brain the knowledge of what he said in a 2 hour, I think it was an hour and 45-minute long interview on the day that his child died. Okay? So in the 8 hours following the time that Jay Williams found out that his baby was dead, he spends 4 of those 8 hours at the America's Police Department sitting in waiting rooms or interview rooms. He spends most of that 8 hours sitting there. He spends 4 of those hours being actively questioned by Agent Ford. Okay, so you say, did you tell her that without showing him the interview, without showing him the statement, without letting him, look back over it and say, well, I don't know what let me see exactly what I said in that 2-hour interview. And Mr. Williams says, yeah, I told her he fell out of the chair because that's what he had been told, and that was the only information he had ever had about what happened to his child. He told Coroner Wright that Poague had told him that J.D. fell from the chair. But Poague also told Coroner Wright that J.D. fell out of the chair, that he was in a chair eating chips and then he was in distress and fell from the chair. She told Wright that Jay had been gone for 5 to 10 minutes at the time the fall occurred. That is the sum and substance of the evidence of the people who have testified in this trial, based on their memories, based on their reviews of records, etc. That is the sum and substance of what the direct evidence is about the events of that day. But it's not just direct evidence, ladies and gentlemen, that you make decisions on. And the court is going to talk to you about circumstantial evidence. Okay. What circumstantial evidence is proof of facts or circumstances, actually by direct evidence, from which you can infer other facts that are reasonable and justified in light of your experience. Sort of like if the child gets his head bashed in and his liver busted 20, 30, 15, 5, 35, 33, whatever, minutes before the doctor sees him, and he's 18 months old, and he's in a dorm room on the GSW campus, and there's only one person in the room with him when it happens, well, those are two direct facts, okay? Those are not circumstantial, those are two direct facts, and the circumstantial evidence is when you take those two direct facts and you make the inference, which is, under these circumstances, the only thing that reasonably could have happened was this. This is really important. Judge Sizemore is going to tell you that the law does not require more or greater certainty by you if you're returning a verdict based on circumstantial evidence rather than on direct evidence per se. Okay, and that's because there is no rule that either circumstantial or direct evidence is stronger than the other. The comparative weight of the evidence is an issue for you to decide, just like it is if it's all circumstantial or it's all direct, if it's all testimony or it's all documents, if it's all video or it's all audio. Ultimately, it's up to you to make the decision as to what the evidence means and what conclusions you can draw from it. So, you take those things into account, you think about it this way, you say, okay, now we know some facts, we know some direct facts. So, what are the conclusions that can be reached from the direct facts? Well, I'd suggest to you that there's only two possibilities, okay? One is that it's accidental trauma, that's a possibility, or that it is inflicted trauma. That is, that those are the only two possibilities. But accidental trauma, ladies and gentlemen, is not a realistic explanation. It's not even close to a realistic explanation in this case. It's not a realistic explanation, well, for a whole bunch of reasons. Okay, it's not realistic because you would say, how many times you fall off the bed now? How'd you get this bruise? And these bruises, and these bruises, okay? And they're not just bruises, okay? I'm not picking them up and showing them to you again. Right? But you saw the medical examiner showed you, were they like looking at the scalp on the skull on either side? Okay, there's brain bleeds here, and there's hematomas here, and here, and here, and then there's bruises here, and here, and here, and those things don't all come at one time. Those don't come from one fall. Maybe if you fall off the side of a mountain, and you roll 500 feet, bouncing every which way, you might bruise your whole body. Okay? They might occur in one event or at one time if you're in a car wreck, and there's one impact and you get impacted from every angle. But those kinds of injuries, it is not realistic to think that they could be the result of accidental trauma when there is such a collection of them, and they all occurred within the same within the same time frames. I think is what Dr. Clark's testimony was, that he thinks that those injuries, because they're consistent with each other, they're all new, they're all fresh injuries. Okay, the Dr. Oleg testified, like about the liver, for instance. She says that the liver, that you can tell that it's not an that it's not a chronic condition, it's not something that's been going on, but you do that from the lab results, because you look at the lab results, and the liver enzymes are up, they're not 20 times higher than they're supposed to be, or 100 times higher. Okay, the liver enzymes in one case are like 200 plus times higher than they're supposed to be, and the other 400 plus times higher than they're supposed to be. Okay, and the reason the liver enzymes are so jacked is because it is an acute injury. It is something that has just happened within a short period of time. Now, none of the doctors are specific about that injury or about the bruises. They're not as specific. They're not saying we can narrow it down to an hour, or within minutes or whatever, because, there is a broader range in which those things could occur. But when they are there, when they aren't there, and then suddenly they are, and when they are there, they are in the presence, or they're associated with, or in addition to an injury that can be timed or dated, then you know that they almost certainly occurred all at the same time. Accidental trauma talks about falling off the bed. The only evidence in this trial of a fall from a bed, okay, all of it, the whole total of all the evidence. Nobody was told by Trinity Poague at the hospital that fell off of a bed, that the baby fell off of a bed. Jay Williams wasn't told that he fell off of a bed. Okay, the police officers that she ran across at the hospital weren't told that she fell off the bed, that he fell off the bed. Dr. Bussman said that he remembers, he said he didn't have a specific, he said he didn't know if there was a specific note, but he didn't remember for sure, if she said chair or what, but something about a fall, and he says, all I know is that when I asked her about it again a few minutes later, she completely changed her story. Okay, that's what Bussman told you. And that's not Bussman going back and looking at notes, okay, that are recorded by somebody else, etc. Okay, that's Bussman's memory. He says, I can't tell you what the stories were, but I can tell you that it changed significantly from the first time I talked to her, the second time I talked to her. Okay, so the only evidence of a fall off of a bed is this. I'm sorry, I think I skipped something here. But anyway, so you saw the message earlier, and I may have it out of order, and if I do, I'll apologize for that and try to do better next time. But you saw the text, you've heard it already, where she says that she told Jay to get on the bed, or she put the baby on the bed with Jay, and Jay let him roll off the bed. And she says, he's okay, he's fine. Okay? So, not only does she say he's fine, but her next text to Paris about what happened is this. Paris, this is when she's at the hospital. Paris says, did they say what happened or why they think that? She says, he hit his head at some point. I don't know. They won't give us much information. And Paris says, wait, didn't you say he fell off the bed last night? And her response is, I don't know. I was asleep. She doesn't know if he fell off the bed. That's what she tells Paris the next time the topic is raised. I don't know if he fell off the bed. I was asleep. The next thing she tells Paris is 3 hours later when they're talking about the skull fracture. Paris says, you texted me last night and told me he fell. That had to be it. And Trinity Poague's response is, but that was only off the air mattress. And the air mattress wasn't far from the ground. I can't text about it anymore. I don't know what's going to happen to me. So you have the one text, which is the only evidence of a fall from the bed, and in the next two text messages concerning that matter, Trinity Poague says, I don't know if he fell off a bed because I was asleep. Oh, and he just fell off of an air mattress. Rolled off of an air mattress. Not only that, but the timestamps, and I think this testimony was in earlier, okay, the message about he fell off the bed was at 11:57 p.m. on Saturday night, okay? At 12:02 and 12:04, and I will tell you that I'm not 100% certain which one of those two videos that this screenshot comes from. But it's from one of those two, either at 12:02 or 12:04. Okay, either no, maybe more than 10 minutes after the child fell off the bed. But it is 5+ minutes since she sent the text saying he fell off the bed. Okay, that is the state of J.D. Angeles. Okay, and you saw the video in court. That's the screenshot, of course. And you look at it, ladies and gentlemen, and there is no big fresh bruise on the corner of his forehead. And he's sitting up, and he's drinking out of a sippy cup, and he was holding on to her hand and playing, as you saw in the video. Dr. Olek, okay, who's also not affiliated with the GBI or anyone else, I mean, other than her own practice, Dr. Olek told you that there is zero possibility that following this injury, the child could be doing these very things. The nature and extent of the injuries can't be explained by a fall from the bed. Too many injuries, too serious. They don't happen like that. And Mr. Gilbert says, you know, he's like, Dr. Clark, you just can't trust Dr. Clark. Now, he works for the GBI. You know, he works for the crime lab, which is true, he is technically an employee of the GBI. He says, you can't trust Dr. Clark. You know, because Dr. Clark's going to say whatever they want him to say, I guess. You know, is what he's implying. It's not the case. Okay? Dr. Clark does autopsies, right? Sometimes the autopsies are, this is a natural death. This is a heart attack. Sometimes the autopsies are, this is an accidental death. You know, sometimes the autopsies are, you know, the death is unknown, it's unexplained. Okay? And those he doesn't get called to testify because nobody's being prosecuted for murder. Okay? The only time he gets called to testify for murder is when he made the finding that this evidence establishes that this was a murder. Okay? He doesn't get called to testify in a murder case because we decided that, oh, we got a murder case. Well, hell, what are we going to do? You know, let's call Dr. Clark. That's not how that works. He does the autopsy. He did the autopsy 3 days after the child died. Okay, issues a 6-page report, orders all kinds of stuff. Okay, comes into court, and yeah, you know, we're going to call him, right? We're going to call him to testify because his actual live, in person, with his hands and a scalpel, findings were that this child was murdered. So of course they're going to call him. So Mr. Gamble says, you know, he says, but Dr. Clark ain't as slick as he thought he was. He says, because I got him good now. I had this article. He got an article. Let me see if I can find the article. Was that up here?
I don't know that it is. I think they gave it back because we couldn't send it to the jury. So I can give you a copy.
It's all right. Okay. This is the thing about the article. Dr. Clark says, well, give me a minute, let me read it. We took a little recess. Okay, he read the article. Mr. Gamble comes back and he says, 4-year-old child in Chicago fell off of an adult bed, died 2 days later of an epidural hemorrhage. You know, 9-month-old in, you know, Portland, you know, fell off of a table, you know, suffered injury, was taken to the hospital and they did not have any findings, died 2 days later from brain trauma. And Dr. Clark says, yeah, he says, I'm not only familiar with Dr. Case or whatever her name is, he said, I'm familiar with her. He says, I'm familiar with the article. I'm familiar with it. He knows the other doctor, too, that's cited in there, Mavo or whatever his name was, who she cited. Okay? He says, yeah, I know these people. Okay? And I know this article, now that I've looked at it. He says, they're talking about epidural hemorrhages. Okay? An epidural hemorrhage is entirely different than a subdural or subarachnoid hemorrhage. And he explained on the stand, and I hope that you got it because, frankly, I probably didn't understand it well enough to try to repeat it to you. But basically, there's different layers between the, you know, from the skull to the top of the scalp. There are different layers. There's the galeal layer, which is the fibrous tissue that's immediately attached to the skull, and then above that there's the dura and the something and something else, okay? And you can have brain hemorrhages, you can have hematomas that result. And they occur in different levels, and depending on what level it occurs on, it's subgaleal or subarachnoid or subdural or whatever. The article was only about epidural hemorrhages. And he said we had a very small epidural hemorrhage in this case. The significant ones were subdural, subarachnoid, and subgaleal. Okay? Article has nothing to do with the facts or the circumstances of this case. Furthermore, you go to the next section of the article, and it says that in almost all cases of subdural hemorrhages in a child, it is the result of abusive head trauma, which is exactly what it is a result of right now, in this case. How many times you fall off the bed? There's an occipital skull fracture, which is back here at the back of the head. It's a hard bone to get to. It's a hard bone to fracture because your shoulders absorb some of the blow if you fall backwards, and this part of your head absorbs some of the blow. And it's the thickest bone in the scalp, or in the skull, rather, the occipital. It's the thickest bone in the skull, he said. It's hard to crack, hard to bust, hard to split. It not only split, it not only busted the full thickness, the fracture went all the way through the occipital bone, but it continued into the up here, the parietal area. Okay? Now, Dr. Clark didn't call it a parietal fracture. He called it a separation of the lambdoidal suture, okay, which is where the two pieces of the skull come together over here, right? And the reason he called that is because it was on the suture line. Okay? But the sutures, they all develop at different times. The sutures solidify, they come together and ossify in the bone at different times in different children, different ages, and depending on where it is in the head, but it says this is bone. Okay? It was just on the lambdoidal line. Okay? The other doctor who did the x-ray, and this is what Jill Olick testified to, she said it's an occipital and parietal fracture, okay? But in any event, the fracture goes from here all the way up here. There's bruises on the face side in front of the head. There's a lacerated liver and a lacerated adrenal gland. He didn't have any of these conditions or injuries when he got to Americas on Saturday night. So did he fall out of a chair? Right? That's the... Yeah. We went from falling off the bed to falling out of a chair. And I will tell you the same thing that I told you about the other fall, because it's just as applicable. The nature and extent of the injuries cannot be explained by a fall from a chair, particularly not a fall from this chair. That chair, the part that you would fall over, okay, is only 13 inches off the floor. Okay? So, if you fell over that, the only way you could fall out of that chair is to fall forward. You can't fall backwards in it. Y'all, everybody here probably has seen one of these chairs or something like it before, I bet. And your kids probably have had one and all that. And it's a big fluffy. Probably is kind of a beanbag thing. The cushion's beanbaggy. It's not a whole beanbag chair, but the cushion's beanbaggy. It's a big fluffy thing. Okay, when you sit down in it, okay, the way it's shaped like a dish, you sit down and you basically sink into it. Okay, you couldn't turn the thing over backwards. If your life depended on it, not from inside of it. Okay, and if you fell forward out of it, even if you were only 18 months old, if you fell forward out of it and landed right square on your face and busted your forehead and did this and that and knocked out an eye and all kinds of things, you still wouldn't fracture the parietal bone and you still wouldn't fracture the occipital bone. If the injuries cannot be explained by falls, the only realistic possibility is that this child was a victim of inflicted trauma. Okay? There's just not another explanation. I mean, it's either accidental or it's inflicted. And if it's accidental, if it's not accidental, it has to be this. And if it has to be this, if it's this, then it has to be by who is the question. Okay? So, Jay Williams. Did Jay Williams inflict the trauma on this child? That's one hypothesis he offers. Okay? I was kind of stunned by this one. The other possibility he offers is, JD himself. He's active, climbing, growing, 18-month-old baby. He might have done this himself. There's no telling what he climbed up on and fell off of. I'm serious, that's what he said. He said that to you. Like, you gonna believe that? Like this child, managed to come. Now, if somebody had come out of that bathroom where they were, okay, and the child had been laying face down, not breathing and unconscious and in respiratory arrest and with brain fluid seeping out of his mouth and his nose, okay, if you've been laying like that face down, on the side of the desk over here, and that was the only injury he had, sure as heck it could be accidental in that case. Yeah, it might be. But to think that the kid climbed out of, it's too dumb for me wasting more time. I'm running out of time for me just wasting more time talking about. A kid did not climb on anything and fall off and hurt himself. So, the only other option, the only other person is Trinity Poague. Now, I'll grant you that this case depends in significant part on the credibility of Jay Williams. It does. Every case has witnesses. Some witnesses are more important than others. Some witnesses are essential to a case. Some witnesses, are kind of interchangeable. You can use this one or that one or whatever to prove whatever you're trying to prove. Jay Williams is an essential witness in this case. Okay. But I'm telling you, when you assess his credibility, the judge is going to give you a charge about assessing credibility. Okay, like you consider their manner of testifying, their circumstances, how they would know the facts and circumstances that they're testifying to, their ability to observe, whether it's corroborated by other testimony. Okay, his testimony was corroborated by clear, undisputed evidence. Okay, there is a video from GSW that Chief Lewis played for you. Okay, that shows him walking out of the dormitory at 11:55, and shows him walking back in at 12:30, and shows him running out with a baby squeezed up against his body right here at 12:31. Okay, he wasn't there. Not only that, he said he was going to get a pizza. Well, how about this? There's a pizza, okay, right there on the end of the bed. Says he's going to Walmart. Well, there's Walmart bags, and there's stuff in the Walmart bags, and reach in, and you take it out, and you take a picture, and I'm not, so, well, there's Walmart bags. There's a receipt that says that these things in this Walmart bag were paid for at 12:14 p.m., okay? So if he left the dormitory at 11:55, and he's at Walmart walking out at 12:14, I'd say he's moving pretty efficiently if he managed to get there and to pick up items and get through the cash register in 19 minutes. But he did. Okay? His statements to Allen and Mathis, okay, to Mathis Wright, I said Mathis, I should have said Wright, I'm sorry. His statements to Lieutenant Allen and Reverend Wright were consistent not only with what he told them, they were consistent with what Poague told them. Okay? They're consistent with what she told them about falling out of the chair, etc. Right? Big deal about the hospital records. Ladies and gentlemen, when you consider the credibility of this witness, I'm telling you, the hospital record does not disprove his testimony. It barely contradicts it. It barely, it's almost it's not a bump in the road. It's a pebble of sand that you walk over. Okay? The hospital record doesn't disprove his testimony. There's no one who comes in here and testifies and says, this is what he told me. I wrote it down right here, word for word. I know this is what he told me. Okay? There's a hospital record that's assembled by a team of people who are working desperately to save the life of an 18-month-old child. Okay? And doesn't disprove anything about what he said. His GBI interviews do not impeach his trial testimony. Okay? Let me talk about this for a second. I talked about it briefly a while ago, but I want to go back to it for just a moment. The GBI thinks, okay, what he... Pardon me, I'm sorry. I have to take a sip of this water. What he told Samantha Ford was that he didn't know what happened to the child. Okay? Now, defense counsel didn't play the interviews for you. He didn't refer him back to specific questions. He didn't refer her to specific questions to say, what questions did you ask him? Did you ask him what happened? He says, I don't know what happened. You know? She says, have you heard anything about it? Yeah, the only thing I've heard is what Trinity told me. You know? I mean, what Trinity told him isn't nearly as important for summarizing the interviews. Okay? It's not nearly as important in Jay Williams' interview summary as it is in Trinity's interview summaries. Okay? So, you know, he says, you know, what did he do? You know, what did he say? He said, well, he told me he didn't know. That's what he said. He said he didn't know. And it may very well be that without those questions being in front of you to know what questions were being asked and how they were being asked, that may have been the full and only and absolutely correct answer. Moreover, his trial testimony was credible. The guy sits there, you know, he's not showing a lot of emotion. You know, it's been 2 years. You know, you come into a courtroom, there's a lot on the line. You know, you're seeking justice for your baby. Okay, there's a lot on the line. And there's y'all, okay? And y'all are a wonderful looking group of people, okay? But I'd be scared to death too if I were sitting over here, okay? And I'm testifying, you know, and I'm asking questions, and Mr. Gamble's asking questions, and are all, you know, giving him the mean eye, you know, not kidding, you didn't really give him the mean eye, but you're all looking at him, okay? You're paying attention to him, okay? You're focused on him, and he knows you're focused on it, right? That is a tough position for somebody to be in. And you try to control your emotions because you don't want, I mean, anybody would. You try to control your emotions because you don't want to break down. You don't want to look, you know, like Jell-O on the witness stand. Okay? So you steel up, you know, you tighten up, you say, okay, I'm going to get through this, you know, and you sit there and you do it, you answer questions cleanly, directly, okay? You answer them crisply, and that is the thing, if you think about, that you will recall from his testimony. That guy didn't evade a single thing, okay? He's not trying to dodge anybody's questions. He's not dodging. He's not ducking and dodging. He's not giving you this, you know, I don't know. I don't remember. That was a long time ago. You know, I mean, he's answering the questions the best of his ability based on what he remembers at the time he's sitting there. His demeanor was appropriate. His grief was palpable. He's at this point he's testified, okay? He's in the courtroom when this happens. And Mr. Gamble says, he says, well, about this jacket that the baby supposedly threw up on. Supposedly threw up on. Okay? So I go back in the records, okay, in the recordings that we have, right? And I look and I say, are there any pictures that actually show the jacket where it's puked on? You know, well, sure enough, you have it back there, you know, you look at it a little closer, and you see just how prominent that is, okay? It is all down, look, wrong side. It's all down this side of the jacket, okay? It's not only down this side of the jacket, it's inside the collar, okay? I mean, it makes my stomach weak just to hear that, okay? About, you know, I mean, listen, I love my children. I love them with all the world, okay? But my ex-wife was a nurse, okay? And when young'uns started throwing up, you know, okay, I do everything. I changed diapers, I cooked meals, I did all kinds of stuff, okay? The young'uns started throwing up. I'm like, Betsy, come here, you know, because I couldn't stand it, okay? It makes me puke for them to do it. This guy tucks that child against his shoulders, gets in a car, races to the hospital, and while he's doing it, this kid is puking on him, not on his clothes, not on the floor, not on the seat of the car or in a baby bed somewhere. He's puking down his neck, down his shirt, inside his jacket. Okay? He doesn't let go. He doesn't let go. He doesn't stop holding him. He doesn't stop going to the hospital. He doesn't get to the hospital and say, here, somebody take this nasty young'un. Look, he's done yacked all over me. He carries him in until he puts him in the hands of somebody who might try to save his life. And we're gonna mock him and say, supposedly someone threw up on his jacket. Come on. He was credible. He was credible as to what he testified to. And ultimately, ladies and gentlemen, there is this. He has no reason to harm his son. Now, Mr. Gamble says, you know what? They should have gone to Colquitt and talked to neighbors and friends and all this kind of stuff and asked about all that. And, like they should have been investigating Jay Williams. Well, first of all, they make him sit through 4 hours of interviews, on the first day. Right, and they take his phone. Okay, they do a search for a search warrant. They snatch his phone too, not one, two phones. They snatch 2 phones from him. Okay, and they're investigating. But and when they're the dormitory interviewing people, okay, they're not interviewing people to say, tell me what you know bad about Trinity Poague. Okay, they're saying, tell me what you know about this baby being in the dorm last night. And then from there, it may go on to other questions. But saying, what do you know about the baby being in the dorm? Left. Gone. Okay. So that's what they're asking for. They're not trying to build a case or attack the character of this girl. That's not what they're doing. Okay. And there's no reason for them to go to Colquitt because I tell you this. Okay. He's got an apartment in Colquitt, right? If this child had died in Colquitt, Georgia, on Sunday, January 14th, 2024, okay, and Trinity Poague had been there in Colquitt with him when it happened, you think they're going to be coming up here talking to people that live on the dorm? No, they're going to be talking to people in the apartment next door, in the apartment across the street. And the people that he sees in the parking lot, the people that he sees at work. But those people don't have relevant information in this case, okay? They might have relevant information if this child had died of malnutrition, okay? If he had died as a result of, septic shock for some wound that didn't get treated, okay? If there was a negligence case or something like that where you have a baby that just doesn't get taken care of, okay, where defects has been involved, all these kinds of things, if you have that, then sure you go interview the neighbors, etc. Okay? J.D. Angeles died because something or someone smashed him in the back of his head and cracked his skull open and then smashed him again and split his liver. Okay? He didn't die because he had some sort of chronic abuse. He didn't die because he cried at night, and the neighbors somewhere else didn't hear him. Okay? Nobody's aiming for Trinity Poague. Nobody's aiming for Trinity Poague. Hey, I'd rather have a different defendant, okay? If it were me, right, if I got to choose who my defendant is, I mean, I'd rather have somebody that looks mean and surly, and is older, and somebody looks at him and says, oh, he just looks terrible. That looks like a guy who would do this. That's who I'd rather have as a defendant. Okay? Not an 18-year-old college student, or 19, 20, whatever she is. They're not after Trinity Poague. They're trying to determine how this baby died and who was responsible for it.
Mr. Lamb, you can conclude your argument.
Talking about Jay Williams said that you can see by not only his demeanor in court, but the things he did, his actions, the way he came out of the dorm, holding that child, and all that, and to my knowledge, no one had ever asked. I certainly had never asked until it came up in this trial. But then he testified to it. I said, so you're talking about your jacket, and they're talking about why we didn't collect the jacket to test for vomit. And he says, well, I guess you still could. And so that's what put him back up on the stand later, if you'll recall. And I said, so do you have the jacket? And he says, yeah, I've got it. But where is it? Is it home? He says, I said, what's it? He said, I never washed it. Shirt either. They're there. I said, well, why hadn't you washed it after 2 years? And he said, because it's the only thing, that's the last thing I have left from my baby. Okay, that guy is not going to beat this youngin' to death. Okay, Gamble's giving you a 5-minute window in which, I'm sorry, that hand I heard on the table saw, and it looks funny to me when I hold it up. He's not going to give you, he's giving you a 5-minute window, okay, where he says it had to happen. You know, that Jay Williams could have done it. He could have done it in this 5 minutes while she's in the shower. Never mind, they're still in the same damn dorm room, okay, but he says he could happen in this 5 minutes that she's in the shower and he's out there with the baby. Okay, there is nothing about Jay Williams that would lead you to believe or support the conclusion that he would have done this to his child. Who had a motive? If you could have a motive, right? Like these cases are hard. Okay, I think Mr. Gamble may have misinterpreted me when I said that this is easy. I'm talking about that element of the decision-making process becomes easy when it gets to this kind of a case. Okay, but these cases are hard because these are the cases where every jury is going to give every defendant the absolute most presumption of innocence and the most benefit of reasonable doubt ever, because in your heart of hearts, like every other living, breathing human being, okay, you don't want to believe that somebody could do something so terrible to somebody so innocent. Okay, nobody wants to believe it. Right? So if you get past that, ladies and gentlemen, in your deliberations, you get to the point where, you know what, I believe it, okay, you've passed the reasonable doubt stage, okay, because you're giving her anybody else, you're giving anybody in this position, because you don't want to believe it. Nobody wants to believe it. So how do you make yourself believe it? How do you accept that Trinity Poague could do such a thing? Okay, yeah. So she have a motive. She resented and ultimately despised that little boy. Okay, now you know this from her statements, her text messages, etc., starting back in August of 2023. All right, starting in August of 2023. These are in evidence. Remember, they started these exhibits. These are the text messages that came from Paris Permort's phone between her and Trinity Poague. He started the back and moved forward because that's the way they're stacked up here. And she says, I'm going to sleep in your room. I can't do JD crying that much. Hopefully he's in a better mood in the morning. Okay. Then she's talking about getting in the shower, and she puts him in there to wash him in the shower, and he gets water spraying on his face, and he apparently didn't like it and was acting, reacting to it or whatever. And she says, I'm trying to take a shower and I had to bathe him, and I just sat him down and let him cry because I'm not about to baby him. Okay? I'm not going to baby a baby. When she was talking about Jay Williams, I'd say, I don't blame you, girl. I wouldn't baby him either. Right? Grown person. She's talking about a little kid. She's talking about a kid that stands that tall. Okay? That's unsteady on his feet still. And she said, I'm not going to baby him. The witnesses that came and took the witness stand that were called by the defense said, oh yeah, she didn't like that young'un. She didn't like him. She didn't like him. And not only that, he didn't like her. He didn't like her. She sends more messages. In August 17th of 2023, she says, why do I feel anger towards JD? When we were in the bed and JD kept touching Jay's face, I almost cried. Okay? Because the kid is being affectionate towards his daddy, it's upsetting her. And Paris doesn't understand. She says, what do you mean? Like you feel anger towards JD? She goes, I don't know, not jealousy, but I want to love him. But instead of loving, I just feel like angry, like I want to punch him. Laugh my ass off. Oh my God, that sounds so bad, doesn't it? Yeah, it does. It does. It does sound that bad. And then the explanation comes in the next two messages. Ever since he's gotten here, Jay has not touched me. He's currently on the floor. Okay? The baby is interfering with her relationship with Jay Williams. Later, 5 days later in August, she sent a message to him, to Jay Williams, and she said, I told you from the beginning I would always try to love JD the same as mine, but since me and you have gotten serious, every time I see him I just get angry at the world, and I just have a gut feeling of anger. I don't know what it is. But just seeing him makes her angry. In December, she sends a message and now I'm going to come back to it. Let's go to January. The day before, the night before, he was murdered. She says, what are y'all going to do about tonight? That's Paris's text. And the response is, no clue. I guess I'll probably sleep on the air mattress in the sink area. I can't do being around JD anymore. He hates me and I hate him. And if you examine her conduct towards the child, ladies and gentlemen, no, you will see that in fact that is true. There's an old saying that says when people tell you who they are, believe them. November of 2023, she told Jay Williams that he had hit his face, had hit his eye, that he bruised his eye or cut his eye, injured his eye, that she was cleaning up near the camp in the bathroom, and she didn't realize he was behind her, and she opened the door or the drawer. I don't remember which one he said. But she opened it up, and she hit him in the eye. Hit him in the face. She said, I felt so bad. I felt so bad. Okay? Where is JD when he gets the blow to the face? Okay? With Trinity Poague and nobody else. He ain't with his daddy. He's with Trinity Poague. In December of 2023, she sends a message that says, Jay, this is December 17th. She says, Jay, I don't know if I can do this anymore. This weekend was a struggle for me, and I don't know what to do. I love you so much. But letting JD hit the wall and see the damage it did really hurt me. Okay? What in the world is that about? Hitting the wall. I asked Jay Williams when he testified, he says, I don't know. I don't know what she was talking about when she talked about him hitting the wall. That baby was terrified of her. You heard those people that said he cried and cried and cried when she was there, and he would stop crying if somebody else picked him up. That was his reaction. There's an old saying, something like, I never trust people who don't like dogs, but if a dog doesn't like a person, I trust them completely. And I'd submit to you that basically the same thing is true of an infant. Okay? Like, you don't like babies, you don't like little kids, you don't think they're fun and I don't know, cuddly and snuggly and just wonderful, creatures, I'm sorry. If you're not that person, okay, and little kids know it, okay, they know, it's like, they're not going to go to that guy, they're not going to go to that girl, they don't want any part of her, okay, and I'm there's these things that have happened, and they happen when he's with her. Okay? And in this case, ladies and gentlemen, this is really important. I'm going to try my best not to run out of time, and I'm sorry, I didn't mean to talk this long. In this case, he says she hasn't given any confessions or anything, like they don't have anything on her. That's what Mr. Gamble said. I wouldn't have said that. Couldn't say that if he hadn't said it first. There's not. He's right. There's not. Okay? But there are implicit admissions that this case happened under her care, under her eye. Okay? There are implicit admissions that this happened. One of those implicit admissions is that she lied about what happened. Okay? The second one of those implicit admissions is that she changes the story. She creates essentially two separate events in talking to two separate sets of people to explain it. Okay. Third, she sends the text when she's at the hospital, and she sends the text to Paris. She says, babysit all the time, and nothing like this has ever happened. Okay? Okay, now you parse that statement. You think about what that statement means. Okay? If I say, Stephen Douglas drives my lawnmower all the time, and nothing's ever happened to it, okay? You know, until now, right? I'm blaming Stephen Douglas. Okay, I'm saying this is different for Stephen Douglas. He drives my lawnmower. He doesn't normally break it, you know, but he did this time. Okay, if I say, if he breaks my lawnmower, okay, but I say, I've had this, you know, I have had this lawnmower for years, you know, and nothing's ever happened to it, okay? And then I turn around and say, you know, it's an implicit admission, and my analogy may not be very good, but I think that you get the point, okay? That if she wasn't involved in this, if she didn't do anything, then the answer is, I don't know. Not he fell off the bed. Not, oh, no, what off the big bed, it was off the air mattress. No, it fell off the chair. No, it didn't fall off the chair, slumped over in the chair or something. Okay? I don't know is the answer if you don't do something. But if you do something, you're trying to explain it, or trying to absolve yourself of attention and criminal responsibility, then you come up with other things and other people to blame, etc. All right. I've left this part for near the end, and that is talking about this offense, malice murder, okay, which is a separate charge than felony murder. A person commits the crime of murder with malice aforethought. He causes the death of another human being. Okay. The court is going to charge you, I think, that there's two kinds of malice. Express malice is a deliberate intention to kill, which is manifested by external circumstances that are proven. Implied malice is when there's no considerable provocation and circumstances show an abandoned and malignant heart. Okay? Ladies and gentlemen, there is implied malice in this case. There is implied malice. Okay? Now, I will not tell you, and the judge is going to charge you. Okay? He's going to tell you that we don't have to prove. Nobody has to prove that because foreplan, that they will plan premeditation. We don't have to prove premeditation. Okay, that's not part of the burden of proving malice murder. He's going to tell you that malice can be formed in an instant, and in an instant, a mortal wound inflicted, and it's malice murder. Right now, the reason that I'm bringing this to your attention is because you could reach the conclusion from this evidence, okay, that she either just lost it for whatever, that he left her with the baby again, he's going to get pizza and drinks, she's already mad because the baby's ruining her weekend and all that. Okay, and he left with the baby, and the baby won't shut up. The baby was crying last night, half the night. She, had to get up and go to Paris's room till 2 a.m., and she's trying to play with the baby and wake him up. And now he leaves her with the baby again, and she gets out of the shower, and he's crying, and he won't shut up, and she just flipped out. Okay, and maybe she doesn't intend, I don't think, what I think doesn't matter. I'm not trying to prove, and I'm not trying to suggest to you or make you believe that she looked at him and said, I am going to kill you, okay? Like I'm not trying to convince you of that, okay? But I don't have to convince you of that for you to find malice murder, okay? What you have to find for there to be malice murder is that there's no provocation and the circumstances show an abandoned and malignant heart, that there's just a point at which somebody just goes too far, okay? And when you use your hands or the edge of the bed or the edge of the desk or the floor or the wall or whatever the weapon was to cause this kind of damage, then the evidence is sufficient to show that she's guilty of aggravated battery and first-degree cruelty and felony murder and malice murder. Now, Mr. Gamble has made a big deal, as he should as a defense lawyer, about reasonable doubt. And he says, this is reasonable and that's reasonable. Okay, the judge is going to charge you that we don't have to prove doubt beyond all certainty, or to a mathematical certainty. We don't have to prove guilt beyond all doubt or to a mathematical certainty, right? And we don't have to disprove every ridiculous hypothesis or allegation made by the defense. Like, I do not have the burden, frankly, of proving to you that this child climbed up on the dresser, and did a high dive on the floor, of his own accord. Because he'd had one injury, not a whole panoply of them. Okay? I don't have to prove that. I don't have to disprove that hypothesis because it's not reasonable. It's just dumb. And when you look at it, you say, this is not reasonable. Okay? So if there's some hypothesis that he's tossed out there that I haven't addressed, that doesn't mean that I failed to prove it. You can take the evidence and analyze the evidence and say either this hypothesis has been disproven or not disproven, or this hypothesis is not worthy of attention in proof. When you consider the evidence, something else you take into account that there are two specific false narratives, okay? And these are not just arguments that are where somebody's off track on something, okay? These are false narratives, okay, that have been promoted to you since opening statement. In this case, I just didn't get to say anything about it until now. Since opening statement, okay, that the diaper. It's not said directly, but it is implied, okay, that the reason James Gibson threw away the dirty diaper when he was examining the trash out of the trash bin on January 14th, the reason he threw away the dirty diaper was because there was a defense motion to test it. He files a motion and says, "Ha, we don't have it. It's gone." When I had to come to court and answer for it. Okay, that's not what happened at all. Okay. Gibson, as you heard from his testimony, made an independent judgment. Okay, maybe he's even wrong. Okay, everybody's wrong sometimes. There's not an agent that's good enough not to make mistakes. There's not a lawyer, a doctor, a cab driver, a carpenter, or anybody else that's good enough that they never make a mistake. And maybe Gibson's wrong. I would stand by the decision he's made as his fellow agent has done, but it had nothing to do with an expectation or worry or fear that it was going to be tested. What it had to do, and the fact that it was photographed, unfolded and photographed, doesn't mean that he saw it as being of special importance, but he wanted to hide it. Okay? If he saw it as being of special importance and wanted to hide it, he wouldn't have photographed it. The photographing is like everything else was in the trash bag, and he told you, he says, I opened up chip bags and cups and wrappers and all kinds of things. Okay? He photographed everything in there, not just the diapers. Okay? The second false narrative, okay, is that Jay Williams isn't legally J.D.'s father. And maybe he's not. Maybe he is, maybe he's not. Okay? But that has nothing to do with this case. It is a fact, it is a reference that is not even necessary to have been made in any context or circumstance whatsoever. Okay? It is designed to make you think that these people, the family of this child, do not deserve the same measure of justice that somebody would if they could say, not only is me and my wife, but I've got 9 DNA tests to prove it. This is my kid. Okay? Can't do that, can't do that. Certainly can't do it now. Okay, I bet he'd love to have a paternity fight now. Love to. Say, yeah, I'll fight about it, and if I lose, I'll kiss him on the cheek and say goodbye. Okay? But he can't. Whether he's his father or not has nothing to do with anything. Petty contradictions due to different perceptions or memory lapses. And we talked about this before, and I'm not going to go into it much further. Okay? Somebody says, oh, look, this is what I said. And they say, no, that's what you said. And it's been 2 years or more, and they're in 2 different contexts and 2 different eyes viewing things, or 2 different sets of eyes, and sometimes they don't see things the same way. Failure to find or recover a weapon or other physical evidence at the crime scene. He says it can't be a crime scene because there's no blood. Okay? Some crime scenes don't look like the Manson family has been there. Okay? Some crime scenes, there aren't walls full of bullet holes. Some crime scenes, there's not anything in the room that specifically points to it and says, a murder happened here. Okay? Why would he not luminol the whole room looking for blood? Because he had just left the hospital and the child didn't have any external injuries. Okay? There's no blood because he wasn't bleeding. Whatever happened to the injuries that he suffered resulted from blows and force that caused him to have internal injuries that cost him his life. There's no weapon. Well, that really ain't right. I mean, that's really not true. Look at here. You heard testimony from the stand that if you pick the child up, Clark said it, if you pick him up and you held him by the shoulders like that, you slammed him down on a hard surface. And Clark said something like a desk or a chair. I think were two of the 4 or 5 things he listed. Well, see, there's a hard plywood chair, there's a desk, and there's another desk, and there's a bed, and there's other photographs in here that show the end of this bed, where there's a bed post about that big that sits on the corner of it. Okay, and the fact that I can't come in here and say we have a videotape of her, smashing the kid against that chair, or, hurling him against the wall, or hurling him against the bed, and the fact that I don't have a video of it, he's going to tell you that that means that you can't convict? Come on. I do have a picture. So you can see the bed. They're like the corner at the corner of the mattress right there. You can see it's like a metal bed post that sticks out of the thing. Investigative techniques, not a reasonable doubt. Joint interview. Okay, Samantha told you, Samantha Fort, I'm sorry, I didn't mean to refer to her by first name. Agent Fort told you that she had interviewed Jay Williams twice for 4 hours. She had interviewed Ashanti Burr before as well. I don't recall what the specifics of that particular interview were. What I would submit to you is that if it made a difference that in the third interview after their statements had already been made and sort of nailed down and this is coming back for additional information, if it made a difference, then he would have played the interview and said, look here, this is why, they're in there together. This is what's messing up all these statements. This is what's causing the testimony or the evidence to be tainted. Okay? It may be poor technique. Okay? It may be poor technique. It may be a violation of what you learned in investigator school to put 2 witnesses in the same room and talk to them at the same time for any period of time. Okay? But it doesn't create a reasonable doubt when that's not the evidence that the case relies on. Declining to order or obtain irrelevant testing. Okay, the diaper, the vomit. Oh my God, I can't believe we're still talking about this. Okay, so the diaper, what's his name? Dr. Busman says, in this light, looking at a photograph that was taken under flash, and then put on a computer, processed through, displayed on this screen, which I'm sure has exact true color under this light. It looks red, right? Like he's not trying to fool anybody. He's not trying to joke about it. Does this diaper look like it's got blood in it? Yeah, it looks red from here. Okay? And then, he's right. I believe that you saw that the significance of that was lost on Dr. Busman. Okay? He didn't understand why anybody was asking about, a dirty diaper. Okay? The significance of it wasn't lost on me, however, which is why I came back and pursued other questions. He says, the state bent over backwards to get him to back up. No, I asked questions on redirect, which I'm allowed to do, which I'm authorized to do, which I'm supposed to do to clear things up. Okay? And when I go back and ask Busman, what is causing? He says, it doesn't have to be blood in red, something red. Well, you know what? If you look at that picture, and I'm not going to try to scroll back through it because I'll lose my place forever if I do, okay, of that child in the car seat coming from Colquitt to Albany when they went to meet at Chipotle, and he's got a sippy cup, okay, it has a liquid in it that is as bright red as the top of this cabinet right here, okay? He's drinking, a big cup of red fruit punch or whatever, okay? So what if he pooped red? If it mattered, then it'd be a different story. But there's nothing to suggest that it mattered because there's no illness, disease, or any other process that could have ever been detected from a red poopy diaper that would have led to a conclusion different than this young'un died because somebody smashed him in the back of the head. There's a lot of audacity floating around this courtroom, okay? Jay Williams, okay, we're going after Jay Williams' parenting skills now. It's like, you didn't take your baby to the doctor for his 9-month and 12-month and 15-month checkups, Jay. You know, the world is looking at you, buddy. You know, Jay, I can't believe this. That baby is only 18 months old and weighs 25.1 pounds, and you have him in a forward-facing car seat in a sports car. My. You know, the drama, the tragedy, the humanity. Okay? Whatever. Right? If you want to say that he needs a parenting class, you know, I bet you he'd love to have to take one now. Bet you he'd love to have to take one now. You know? I mean, and if a trooper had seen him driving with a kid not restrained in a car seat or something, you know, and pulled him over, you know, he probably would have got a ticket for like reckless endangerment or something like that, and would have been prosecuted by whoever, you know, would have had jurisdiction over it. Right? But whether those things are true or not true have nothing to do with the heart of this case and the evidence where it matters. Everybody in this courtroom's got a job. Okay? We're all here for a reason. The lawyers, you know, I mean, it's my job to prosecute cases. It's his job to defend cases. You know, he's daggone good at it. And, you know, the court reporter, she's sitting over here, she's taking down every word that's said. And we got bailiffs who are monitoring security and doing all those things, and a law clerk and somebody from the clerk's office, and everybody's here for a reason. And, you know, I did this slide and I left off the judge, and I just didn't sound like I'm being a smart aleck in doing it, but I was. I mean, I just inadvertently, I looked up and realized, just like, I thought it said judge. It doesn't. Everybody here has a job. Okay? And you have a job. Okay? Your job, ladies and gentlemen, is this. It is defined by the oath that you gave at the beginning of this trial. Judge Sizemore said, raise your right hand. He says, you will well and truly try this case and a just verdict give according to the evidence. Okay, there's two parts to that oath. There's two parts to that job. Part one is to well and truly try this case. And good Lord, I mean, y'all been great at it. I mean, everybody's been here every day. You know, I mean, people like, nobody's like, hey, look at that juror over there. They look like falling asleep. You know, things that we deal with. Or, you know, waiting, you know, day after day for people who are invariably late and you know, don't come back from lunch and, you know, don't take notes, all those things. Y'all been great. You've well and truly tried the case. You've done that part of your oath. But now, it's time to do the other part of your oath. And that is a true verdict give according to the evidence. Your job is to do justice with this baby. That is your job. To do justice. Do justice not for him. Do justice for his loved ones. Do justice for your loved ones. Do justice for your community as a whole. Okay? Jury verdicts speak volumes. Jury verdicts speak to the speak to the community. Okay? They speak. They say things to the community. People look at a jury verdict and they say, wow, you know, like, man, in America, they let people off for that. You know? But they look at jury verdicts and they say, you know, this is the wrong place. Wrong place, wrong time. Do that. You could send a different message. You could send a message and say, hey, look here, y'all. Everybody out in the world, look here. If you do a pretty good job of like not leaving blood, you know, kill somebody with your hands, you know, smash them against the wall, crush their liver with your foot or your fist or your hand, whatever you need. Who knows? Don't know. Don't know. And the fact we don't know doesn't mean that it didn't happen. And it doesn't mean that it didn't happen at her hands. You want to send the verdict? You want to send the message that says, hey, as long as you don't leave a lot of evidence on the scene, see ya. We'll walk you, you know. We're going to require video. We're going to require videos and confessions before we will convict. You know, if that's the standard you want to set, ladies and gentlemen, that's the standard you set. As DA, I'll try to adapt to it. Okay? But don't let yourself think that you're not speaking beyond this courtroom when you go and sit down to decide this case. Katie Angeles was 18 months old. If you want to do them right, you take this paper, you elect a foreman, and you put a whole bunch of X's down those rows that say guilty. A true verdict given according to the evidence.